Okay, welcome to the American Liberties Call. Tonight we have Lysander, Venable Group, and on the phone with us as guest speaker, him and Ed. And but before we get started, I was just commenting before I started the video, started the audio, um, is and I mean I got to Florida in 1960. And I eventually got into the swimming pool business, and ever since my kids were born, right after they were born, the video cameras came out, and instantly I got one, and it's been a godsend ever since. But I've always wanted to convert them into digital. So for the last week and a half or so, that's what I've been doing, and I found this.
Confused about what swimming pool to buy? Concrete, fiberglass, or vinyl? Chapman Pools invites you to come see our new concept showroom. We don't merely say our pool is the best. At Chapman Pools, we put all three types of pools under our roof, so you can see for yourself what pool is best for you. Payments start at only $103 per month and zero money down financing. So bring your family and friends down for free hot dogs and hamburgers, plus a test swim during our showroom celebration, open 7 days a week. Nowhere is there an installation like it. Chapman Pools, Palm Bay. We want what's best for you.
Okay, and so that was just a little, just showing off, I guess, a little bit of my history because um, I'd had a great pool company, and I worked prior to that to probably the greatest pool company. I've been in business since 1954 and still in business. And but I left that because I didn't want to stay in Fort Lauderdale, and I came up to Brevard here in Melbourne, Orlando, Titusville area, Cocoa Beach, and started my own pool company. And the only regret, kind of a regret, not real, well, just kind of, is I got involved in the truth, in the taxation, in the Federal Reserves, the government. And my focus was building a pool business, and I was doing quite successful, to now focusing on government issues, and this is where I am today. And I don't even have a swimming pool to show for it. But the thing of it is, if you're going to get into this battle, this is one thing I've learned over the 35 years. If you're going to get into this battle, and believe me, folks, it's a battle, don't stress out about it, especially in today. See, when I got in, it wasn't, um, you know, emails and YouTube videos and all this. If we were passing out cassette tapes, here, listen to this tape, listen to this tape, and you had uh, American rights litigators, the Pilot Group, and all these groups, and Save a Patriot, and all of them were passing out tapes. Then it got into DVR, VCRs, and now we got what we use today. So the information wasn't readily available as it is today. But after 35 years of going through many, many people, many groups, and talked to several hundreds, if not thousands of people, I've only come down to just a handful of people that I respect, that I admire, and that I have confidence in, that they will be able to help people that I present to them. And Lysander and Ed here on the tax group, tax court group, is one of them. Out of three or four different groups, I am confident that these people know what they want to do. It's just like I said in my email. I went to tax court 3 times. I thought it was relatively simple. Well, it's not. I got caught, and they even fined me $3,000. But I did my affidavit of, be glad to pay upon proof of claim that I'm a U.S. citizen, and I never heard back from them again. And by the way, all this affidavit and stuff like that is all available to anybody. You just got to talk to me. There is a donation process, but it works. It keeps them off of your back, and that's what you want. So, with that being said, don't fret if you're getting letters or anything like this. Not only do I have Lysander, who I'm highlighting tonight, but I got other people. But each group that I work with has individual um, um, process to do that are unique, and so basically you can choose one of the 2 or 3 or 4, how many I ever have. You can choose what one, if it's going to meet your needs. Two, are they going, is it cost effective for you? A lot of people say, well, Chris, I don't really have the money to pay these guys. I got simple ways of making money, folks. All you got to do is get involved before it's too late, before the banks crash, and then the silver and gold thing, which is my number one. But enough said about me right now, because I'm about running out of throat. I want to introduce Lysander. And Lysander, you said that you're going to talk to us about. I don't have my notes up in front of me, but
well, I've got some notes.
yeah, tell us what you're all about, and and how you can help people.
Well, thank you very much for your very very kind words. And the Venible Group we're not gurus. We don't advocate how you file, what you file, whether you file. We help you if you have done something other than file ordinary 1040s, and the whole thing has gone south for you. We take care of. We help people who are in trouble, and who are getting nasty collection letters and notices of deficiency and other dunning and threatening correspondence from your favorite federal agency. We do not carry. We generally do not carry. How should I put them? I don't want to call them frivolous arguments when I know they're not. But we don't carry arguments that we know from long experience the tax court will label frivolous and just hammer you with it. By the way, my first tax court case, I was fined $30,000 for the arguments that I brought there. I take it as a measure of how good the pleadings were. But I lost, and I expected to lose. Actually, I didn't expect to lose. What a naive chump I was. I thought I was going to go in there and tell them just how exactly this thing worked, and it didn't. They didn't believe me. I was watching Judge Booch with his chin in his hand, his head cocked to the side, looking at me like I was out of my mind for several hours in the courtroom, and that was a real lesson. So in the meantime, the Venible Group, we are procedural technicians. We know IRS procedure and tax court procedure, and tax court is not the only case courts we litigated, but knowing the rules and following the court's procedures are extraordinarily important. And you can win on procedure. You don't have to convince a judge whose very lucrative and prestigious job depends on him not understanding what you're trying to tell him. You don't have to convince him. Procedure is procedure. He knows what it is, and everybody knows what it is. You won't be penalized for using it. So with that said, what I was going to discuss tonight, what I was going to talk about is common misconceptions and myths about tax court jurisdiction. People petition the tax court. They have some odd ideas about about how the tax court jurisdiction works. And before I even get into that, though, I want to mention I know there are a lot of people in the tax honesty movement who don't think the tax court is a viable venue for them. And all I can say is that it has many advantages, and there are a lot of good reasons to go to tax court, even though you may not want to. For the first thing, it's the only judicial forum that you can go to challenge federal taxes without actually paying them. This is a big leg up. What you give up for that, of course, is some of the advantages you would have as a complainant in a district court, but not having to pay the taxes generally makes it the most accessible forum. And although the IRS claims some astronomically high win rate in the court, the truth is, in more than half the cases, they don't win 100% of what they're asking for. So you can salvage the money that it will cost you with the money that you save by taking the case to the tax court. And that would be, first of all, let's talk about the two most common types. The tax court's jurisdiction is statutory and terribly limited. And there's probably a dozen different types of cases they could hear. But the lion's share of what they hear are called notice of deficiency cases and CDP collections cases. They operate differently. That accounts for the great majority of cases that are in court. And so, talking about the tax court's jurisdiction, what I see petitioners do frequently is they'll petition the tax court, and then a little while later, following their legal theories and their tax.
Okay, go ahead.
Okay, go ahead, Ed.
All right, Chappie, it's great to be back on. We were on a couple of months ago on your show, and we had your listeners gave us a lot of support and called us, and we really appreciated hearing from them. The basic message we want to get across about the United States Tax Court, if you're being victimized by the IRS's paper terrorism, you're getting the notices of deficiency, you're getting the notices of federal tax lien filed against you, you're getting the final notices of intent to levy. They're going to take your wages, they're going to take your bank account, they're going to take your Social Security payment or other pension. Best way, and really the only sane way, is to petition the tax court within the time that you have allotted, and you shut them down. If you petition over what's called a 90-day letter, notice of deficiency, the IRS cannot assess the tax that they claim that you owe. So if you can keep that assessment off their books, you don't owe anything, as a lot of the patriots out there know. If you get your IRS account transcript, it will show that you owe zero. You will continue to owe zero if you tie them up in the tax court. Now, these guys they're represented there by IRS chief counselors. They don't have a whole lot of people that will litigate these cases to the extent that we can. Very few people, for whatever reason, petition the tax court. And a lot of our fellow patriots out there, they think, well, I'm not a taxpayer, and it's all a fraud, and it's all a rigged tribunal. That may be, but you can win, as Lysander just pointed out. And what you want to do is get that petition filed, whatever statutory notice that they say it's sent to you by certified mail normally, that says that they're going to lien, they're going to levy, or they have liened, they're going to levy, they're going to assess a deficiency against you. Get that petition filed and stop them. Because if you don't, after not too long, after about, you have 90 days, for example, to stop an assessment. After about 2 more months, the IRS will assess that tax. Once they do, they'll send you a so-called notice and demand for payment. If you don't pay, they can file a notice of federal tax lien against you. Then they can start levy action against you. And you don't want that to happen. You don't want to get to that point. Now, sometimes, unfortunately, you don't get the mail, something happens, the little slip that they say, the certified mail came, it blew off the door, your child put it on the kitchen table, it got buried under something, stuff happens. Well, you have an extra layer of protection with the collection due process procedures. When you get that notice, petition the tax court, because otherwise, if you don't, they've already filed the lien. The notice, the law allows them to file a notice of federal tax lien before they give you a collection due process hearing. But go ahead, request a CDP hearing with the IRS Office of Appeals. You can keep that case tied up for a long time, raising different procedural and evidentiary issues. If that fails, they issue you a notice of determination. Go to tax court, dispute the notice, keep them tied up. They can't levy. You don't want to wager. You don't want to walk into work one day and they say, sorry, it's payday, but you're only getting 30% of your pay because the IRS just sent us a notice of levy. You don't want that.
We just concluded
you don't want
a
them
case.
taking 100% of your Social Security benefits, which they can do. So it's important that these myths about the tax court, it's not for me, it's, they don't have jurisdiction. Make them have jurisdiction, because otherwise you're going to be on the wrong end of a tax assessment, a tax lien, or a tax levy, and you don't want that. So I'll let Lysander take it back from there.
We just concluded a case in tax court that was filed in tax court in 2015. The tax years involved were in 2009, 10, and 11. So from the filing date of the first return that was due until the resolution of this case took over 10 years. This is not a profitable endeavor for the IRS. No matter how much they're going to end up eventually collecting from this guy. And he still has 6 months more to wait until they can begin a levy. That was 2000, from 2009 until 2024. And we did a calculation on what he spent on our services in all of that time. And it was less than what he saved in taxes for other cases that we have done. So there are such things as victories in tax court that may not on the surface appear to be.
Chappie, I just wanted to jump in there. One more thing that Lysander had touched on a little bit earlier. There are some patriots out there that say, oh, okay, yeah, you go to tax court. What you do is you file a motion to dismiss the case for you petition, but at the same time, you put in what we call a kitchen sink petition. You add every single tax year going back to the time that you were age 16, and you petition the tax court and you say, I never received any notices of deficiency on any of these tax years. Okay, well, the IRS lawyer, he goes over his files. Okay, well, you're right on that, and you're right on that. Maybe they might have sent them one or, whatever. But for the most part, if not all, sure enough, no notice of deficiency. Okay, well, the tax court is going to issue a motion or an order for a decision for a lack of jurisdiction, meaning there was no statutory notice filed. Now, what people are doing is they believe that this is some sort of silver bullet that can save them against a district court collection action.
Yeah, I know.
What's that?
I know.
You've heard of this program, Chappie, right?
Well, yeah. Well, and let me just interrupt there for a minute. Richard Boggs, who went to court, he showed the judge that he got a no jurisdiction. The commissioner said they didn't have jurisdiction, and the judge says that doesn't apply here. Tax court cases don't apply here. Move on.
Well, what that all meant, Chappie, was that the order of the tax court dismissing the case for lack of jurisdiction, all that meant was that the IRS had never issued any statutory notice to this person. It did not rule on the merits of his case, whatever tax years were involved. They didn't say he didn't owe anything. It was like a nullity that, it was like he hadn't petitioned at all. So when he was in district court, it was irrelevant because it had no relationship to what was going on in the district court.
Yeah.
So this is not a silver bullet. This is, as we call it, a kitchen sink petition. You throw everything in there, including the kitchen sink, but you don't get a benefit
on the wall.
Right.
Yeah. In fact, not only will you not get a benefit out of it, but even though they lack the jurisdiction, because you're before them during that time, they can sanction you. As you said, you were sanctioned $3,000 at some point. They can penalize you for continuing to file these petitions.
Right.
And unfortunately, that's kind of the primary reason that we see that patriots will petition the tax court, and it's a bad reason. The good reason, you want to stop the assessment, you want to stop the liens, and you want to stop the levies. If you can do that, they'll never take you to district court to try to enforce those things.
Right, because then you can use those elements in the district court. You say, look, I tried to settle it, and they couldn't present the evidence here. What makes them able to do it here?
Well, the thing is that your tax court decision or order in this case, because there's no jurisdiction to proceed, there's no statutory notice that the IRS sent the person. So they really had no case. There was no case. There was nothing decided. That's the order of dismissal. So they never said you didn't owe anything. That's the problem that these patriots that are using this method, they're using this order from the tax court of dismissal for lack of jurisdiction as kind of as I say, a silver bullet to say, oh, look, the tax court said I don't owe anything. That's not so.
Yeah, no, I agree with you. Now, what Lysander said earlier, though, about, I've always argued from the position that I'm not in the territorial jurisdiction, and therefore they don't have personal jurisdiction on me, and I challenge it that way. And I win every time. And so I don't claim specifically I'm not a taxpayer. I don't argue that the code doesn't apply to me, because the code does apply to me. Even if I'm not mentioned in there as one of the people of the Union of the States, it applies to me because I pay gas taxes. So you can't say the code doesn't apply to you, but when the code does, when you're not named as subject or create a liability that the code offers, then that portion of the code doesn't apply to me. But then again, I don't say that. What I do is I ask them for proof or evidence that the code does apply to me in this instance, and they can't do it.
Right. That's the argument that you would make is, that we all know the truth, as you said earlier, about what's going on with the income tax system. The problem is when you're in the income tax system, you got to make sure that these guys cannot use the powers that apply to collection and assessment of all taxes against you.
Right. And that's why I think it's important that people who don't want to go through the hassle and the misery that a lot of people have gone through, maybe even going to prison, pay whatever tax you want. I'm not suggesting that people stay in the system, but get hooked up with somebody that you have confidence in, like your group, and maybe some other groups that I use. But they make a presentment upon proof of claim. And if they can't do it, that keeps you out of the hot water, so to speak. And
Right.
go ahead.
Well, here's the thing, Chappie. When the IRS sends you, let's say, a final notice of intent to levy, they're going to levy your wages and whatever else they can get. You know, if you don't do anything, they're going to levy. You're not going to get a paycheck or much of one the next pay period. If you go into tax court, or first, of course, you have to file your collection due process hearing request with IRS appeals. But if you say, well, I'm not going to do that, it doesn't apply to me, whatever, they're going to levy. If you go into petition tax court with the arguments that you've just suggested, the tax court is going to dismiss the case because you failed to prosecute it. You have the burden of proof typically on most issues there. Once that decision is entered, the IRS is going to levy. You don't want that. There's so much misery out there, Chappie, that could be avoided if people realize they've got very powerful procedural rights that exist in the code that they can take advantage of. But a lot of people disregard them or don't know how to exercise them. So that's where we come in.
Yeah.
I just noticed that Yashua has a comment here that says that if you can prove you never received the notice, then they lose. But unfortunately, that's not so. You don't have to receive the notice. All they have to prove is that they sent it. And what they usually use is what they call their certified mail log. And so what that log consists of is all the certified mail numbers that were mailed on any individual date and the address to which they were mailed. It's just a list, it normally would not be admissible. It's admissible as a business record. But you don't have to receive your notice.
Right. The gentleman is correct to a small degree in the sense that if it's a collection due process case and you can claim I never received the notice of deficiency that they were supposed to mail earlier, then you are allowed to dispute your liability. But again, you have to dispute the liability, and you're not doing that by raising these arguments, which they're going to say are frivolous and nonsense and are not even worth a hearing. And if you have received the notice of deficiency and if you've admitted it, then they say, well, okay, you already had your prior opportunity to dispute the liability. You can't do it in this collection due process tax court case. So you would lose there. So it's very important.
What the IRS is really good for, and I got a guy out of jail one time back in somewhere around 95, is that they say they sent you a letter. And then what a lot of people do is they don't look at the evidence file. Well, we sent the guy's wife down to the clerk's office to look at the evidence file because I wanted to see this letter that they wrote. And the letter was addressed to the proper street address, but to a different city. And once we showed that to the judge, he was out of jail before the sun went down.
Yeah.
Well, that is one way, a very good way, by the way, since you mentioned it, that you can win a case in tax court. Something as simple as the IRS, huge bureaucracy that it is, sometimes it makes mistakes. It's supposed to mail a notice of deficiency under the law to your last known address. Sometimes they don't do that. If you can show that they did not do that, everything unravels. They have to abate the assessment if it's a collection due process case, or they cannot make the assessment at all if it's a deficiency case. So a simple thing like that, Chappie, so you don't have to walk in with, what the Treaty of 1871 or whatever it is says. You can say, hey, they didn't send the notice to my last known address. You win.
Yeah.
Yes, you do. And it's interesting. We won a case. It was a notice of deficiency case for 3 years worth of taxes that they had sent. They had sent the notices of deficiency, the three of them, to an old address, and there was evidence in the file that those notices of deficiency had been returned, and we discovered it in the case file, and they left it out. And we offered it for stipulation. We wanted them to agree that, yep, this is in the file. Yep, it was sent to the wrong address. They would not stipulate to it, even though it was in their own records. What they were doing is they were trying to find out if our client knew enough to realize that he had to place his piece of evidence that he got out of their records, that he had to place it in evidence. They would, and he knew. When he showed up for trial, and he was ready to testify that, yep, here's what I found, here's where I got it, and here's what it means. They called off the trial. They came over and just threw in the towel right there. But they first tested him to see if he knew the procedure for getting his evidence into the record.
Yeah.
They would have allowed him to screw it up if we had not known what he was supposed to do.
Chappie, we've seen so many heartaches occur in the patriot community. I mean, we've seen marriages dissolve. We've seen, dissension in the family. People get nervous, and rightfully so, when they're getting attacked by all these IRS notices, and these liabilities are mounting, and interest is running, every quarter, and compounded daily, and they don't know what to do, and they tend to, make a rash decision based on, some theory that some, as Lysander said, a guru in the freedom movement, and it gets them into even more trouble. And it's just simple procedure, simple evidence, rules of evidence apply in the tax court. They have their own rules, the United States Tax Court rules of practice and procedure. Use those and the law itself to hold, at the very least, hold these guys off to where they can't come after you, they can't touch you. And we're talking for years, minimum.
Yeah. Yeah. And if somebody owed, like, let's say 70,000, 100,000 or whatever, and the IRS, without any court order, without any proper authority, will disarm you from getting a passport. Do you cover that at all?
Yes. That is the relatively new law that allows, if you have, and the amount now is going up, or should be up this year to about $62,000, which they call seriously delinquent tax debt. And if you owe that amount, according to them, on their books, the IRS, they will certify to the U.S. State Department that you owe this so-called seriously delinquent tax debt, and the law leaves it up to the Secretary of State or the State Department to revoke the passport that you have, or to not give you a new one if you apply for one. Now, most of the time, they will revoke it, and they will not give you a new passport, but it's up to their discretion. But when you get that certification, the law allows you two avenues to dispute it. Number one, you can go to a district court, or number two, our old friend, the United States Tax Court, also has jurisdiction to hear these cases.
Interesting.
So you definitely, especially if you travel internationally, and of course there's a lot of good issues that you could raise with regard to that. I mean, what do you owing taxes have to do with your right to go to, a foreign country.
Yeah.
So you can argue
And
these issues in the tax court, or if you prefer, you can go to the district court. We prefer the tax court because in the district court, the government could do what's called a counterclaim possible. Everything connected to you. They say, okay, you're suing us over the passport. Well, you owe $78,000 or $100,000 in taxes, so we're going to sue you about that. Now you're in a worse off position than you were.
as a matter of fact,
you're in
I just received my passport that had been revoked for a while, and I was going to do a test case with my case going to the tax court, but I was so close to the collection statute of limitations expiration that I decided to gamble that it would just go over the edge, and it surely did. I didn't want to hang it up again with litigation, which would have suspended the statute again.
Yeah.
I did not want it suspended. Somebody just asked, isn't there a 10-year? Yeah, isn't there a 10-year max for collecting? Alex asked. Yeah, there is, but there are a lot of ways that it gets extended. Whenever you have a CDP hearing or any kind of tax court proceeding, that suspends the statute. And so frequently you'll see if he followed all his procedural opportunities, it took all his opportunities, a 10-year statute can be extended by quite a few years.
Mm-hmm.
That also applies, by the way, if you file a petition in the United States Bankruptcy Court. That will
suspend. Yeah, that'll suspend the collection statute.
But if you have to weigh the two, well, do I want to try to run out? You may not be able to run out the statute. Some people do. Most people don't. The levy gets on. Last time I think we mentioned we had a gentleman in Florida, by the way, Pensacola area, and the IRS levied his Social Security benefits 100%, which the law allows them to do. There is a law that says they can do 15% of any federal payment. They don't have to go by that law. They can take the whole benefit.
Where does it say? Wait a minute. Where does it say they can take the whole benefit?
It doesn't say that.
6331A allows them, to levy and whatever. There's no limitation.
There's a 15% limit, but it doesn't apply universally. They have worked this out. I really believe Congress intended to have a maximum levy on Social Security of 15%, but there's a lot of lawyers working over there at the IRS, and they worked it out so that that's not always the case. And if you're not depending, as our client was not depending on Social Security for his livelihood, he had other revenue and other income that was plenty for him to live on. They just went ahead and set up this levy. It was 100%. Not only that, they claimed that they could collect past the collection statute, and they did. They collected for quite a while after the collection statute.
Well, their theory was that
go ahead, Tom.
Their theory was that because they had put the levy on Chappie before the collection statute applied, that levy was what we call a perpetual levy. It was good until that person died.
Yeah,
so
because
you don't want to get involved in that situation. If you're depending, especially like a lot of people do, on your Social Security check, you don't want that taken for the rest of your life.
Right.
So there are simple things that you can do, which we've outlined a few, in the tax court to stop these collection activities. It's just vital because for peace of mind, for family unity, and just for common sense.
Also, there was mention in there, somebody says, how can we get a hold of you guys? All that will be given at the end of the call. All that was given also in my email. And also if you're watching the screen, you see my newly updated website that I've had now for 5 years, and I never posted it. you know. And I said, oh, I guess it's about time. Anyhow, I will be listing, um, upon their permission, the people that I recommend, and a little bit of their expertise, or I'm going to get what they want me to say and put it on here. So, it'll give them exposure. And anytime that you contact these people, so I get a little chocolate chip cookie, tell them that I sent you. Okay. So, because it shows that I'm working, and so forth. So, okay. Anything else?
Well, Chappie, what you alluded to earlier was that you had gone to tax court, or you had said you had gone to tax court. Now here, we're exhorting people, please go to tax court, vindicate your rights, stop these guys from collecting and assessing. Well, okay, how do we do that? Okay, I agree with you. We should do that. Sounds reasonable. How do we go about doing that? Because the tax court is, it's got a lot of rules, got a lot of procedures that you got to follow. There's a lot of tricks that these IRS chief counselors that you're going to go up against, they do this for a living. That every single day, every one of those IRS chief counselors, that's their job, is to beat pro se petitioners who are representing themselves, which, according to the latest statistics, is 91% of the tax court's petitioners represent themselves.
Yeah.
So you're going to get up against an experienced IRS attorney, and how are you going to navigate all this? Well, that's where we and some of the other groups that you're referring to come in. We can help you. We've done it. We've helped people. We've saved, not only their money, but, their sanity, their marriage, and everything that's connected to it. And
amen to that. And by the way, you guys are the only guys that I would recommend going to tax court. There's nobody else that I have enough faith or knowledge to have that faith to offer that to anybody. But I've known Lysander for years now, and although we communicated some over the years, but he's always been in my rear view mirror, knowing he knows what you guys are doing. So
and the fact that you're pro se does get you some leniency from the court, but it doesn't get you anything from your opponent. I've seen these guys pull the slimiest kind of tricks that they wouldn't pull against lawyers because they wouldn't get away with it. But
yeah.
To a pro se, no problem.
One thing, Chappie, I wanted to add to that is that we do exhort you to go to tax court if you have the opportunity with the statutory notice that the IRS will issue you, not this kitchen sink petition, as we said. But we also, at the Venible Group, we do district court. We do bankruptcy courts. We do state courts. We do appeals courts. We'll go up to the Supreme Court if we need be. So
do you know how to do you know how to discharge the debt in bankruptcy?
Yes.
Yeah.
So 95% of the federal tax cases, though, that exist in the country are under the tax court's jurisdiction. They have by far, the most tax cases that are litigated. So that's why we concentrate in the tax court, because typically that's where you'll end up, or where you should be.
Yeah.
So that's the overriding message is that don't be don't disregard these notices that come in the mail, the certified mail ones especially. Just don't throw them away or say, okay, they can't. Well, they don't have the authority to do that. Well, you're going to find out the hard way. They claim that they do, and they'll exercise that authority. And you're going to be behind the eight ball. You don't want to have to deal with that.
Yeah.
You don't want to be like the guy that I talked to several years ago. He got in the mail, he disregarded his collection due process notice. He said, well, they don't have the authority. Okay, I'm going to throw that away.
Yeah.
Well, they sent a notice of levy to his bank. Lucky for him, though, he thought. He said, oh, well, the IRS always sends you a copy. Well, they sent him his copy before the bank got the actual notice of levy. So what did the guy do?
Took his money.
Well, naturally, he scrambled down to the bank and he got all his money out. Aha, I beat these guys. He was charged criminally.
Yeah.
Because he obstructed the operations of the IRS by going to the bank and taking his own money out.
Yeah.
And he was convicted for it.
Yep.
So had he just requested his collection due process hearing, none of that would have ever happened.
Well, I've told people over the years, countless of times, people say, oh, well, it came in the old caps name, so I threw it out. Why? Why did you throw it out? You know that's addressed to you, regardless if it's in all caps or upside down. You know that's for you. Why didn't you respond to it? The people that hide, first of all, we want the government to be accountable. So you must be accountable. We want the government to be honest. But first, you have to be honest. And lastly, we want results. And if you're hiding from them, you're not going to get results. You're just going to get a lot more trouble, and more trouble than you're wanting to. I had a guy that I know back, oh God, I don't know when it was, around maybe 98. He was doing real good against the IRS, but then all of a sudden he decided to go blow his head off.
Oh,
I mean, this is what they do. This is the people that we're dealing with.
Yes, and that's the people that we want to save from getting to these points where they end up in jail or they get divorced or, there's so much tension in the home because of the disputes over these IRS notices. There is a way, folks. There is a way. There's an easy way, or I should say a simple way, that you can stop the IRS from harassing you, taking your property and threatening you, and that's why we're here.
Yeah. So what other topic do we have for the next 10 minutes?
well,
We got Lysander. I'll let you take that one.
there was some, I wanted to recommend and talk about making up your petitions. What I find with a lot of pro se petitions is the inability to distinguish between facts and law. Petition is very simple.
Lysander, you're coming in muffled a little bit
Really?
again. Yeah.
I don't know what it is. This is a fancy headset. Maybe I got a bad connection.
Get a cheap one.
Yeah, I should get a cheap one. Hang on, I got another one right here. It's cheaper.
Well,
Let me
the
swap
thing
it.
is, Chappie, what he was getting at was that in drafting, the people that believe that, and they're headed in the right direction, they are petitioning the tax court, but they're making serious mistakes as to what is fact and what is law. They're just throwing it all in the petition and thinking that, okay, I've covered all the bases, this is it. Well, when the IRS chief counsel has to answer that petition and say they admit or deny whatever you're saying, well, a lot of that stuff is conclusions of law that they don't have to answer. So you're letting them off the hook.
Yeah.
You can get them. This is what's called the pleading stage. When you petition and they answer, and sometimes you'll be required to reply, you're letting them off the hook because you should be formulating your petition in a way that they, in effect, are requests for admissions. And
Yeah.
that's a discovery technique where you ask a person the other party to admit to a certain statement that you've made.
Yep.
Well, if you've stated the statement wrong, then they can say, well, it's a conclusion of law. We don't have to answer you. So you're missing a golden opportunity to hold these guys to account right in the pleadings, because you can move for what's called judgment on the pleadings if you can pin these guys down to where they admit a lot of the factual positions that you take, depending on your individual case, of course.
Is this microphone any better?
Well, that's why I recommend you guys, because, if I was going to get brain surgery, which a lot of people say I need it, but if I was to get brain surgery, I certainly wouldn't get a guy coming out of college or, or first couple of years. I want to find the oldest, most experienced guy doing the surgery on my brain, and or at least what's left of it. And that's where you guys have fulfilled that duty. I mean, Ed, I've only known you for a short period of time, but Lysander, what, 15 years maybe or more?
Yeah, I've been in this game for a while.
Yeah.
Well, I think Lysander and I last calculated we have over 60 years of experience in the tax honesty movement.
Yeah.
And I just passed my 33rd anniversary. I used to work with the great Irwin Schiff, and later on worked with the equally great Payman Matea of Freedom Law School.
Yeah.
And I pretty much have seen all the greats come and go, and unfortunately we've lost a lot along the way to death. And there's not, unfortunately, Chappie, there's not many people like the Venible Group and Freedom Law School and others that you've mentioned or alluded to out there anymore. You listed a whole bunch of names at the beginning that, from Save a Patriot way back when, and Pilot Connection, and several others that existed.
Yeah.
Those guys are gone.
Yeah, and I'm not gonna. Well, I don't know how long I'm going to be around, but hopefully another 5-10 years. But who knows? But
Right.
But I wanted to give this up a long time ago, but I can't. I mean, it's in my blood. I can't. When people call, they want help. I can't turn them down.
Yeah.
And yet, but anyhow, that's.
So one of the reasons it was interesting, we didn't quite finish up with the petitioning scheme. One of the reasons you want your petition to read like a request for admissions is that you're first, and it's an excellent opportunity to be able to skip the trial. Most pro se litigants don't understand what the purpose of a trial is. Trial is simply to establish the facts. You don't argue your case at a trial. All you do is you try to get facts. You try to get facts into the record that will favor you, and keep facts out of the record that will favor your opponent. So there's a process in the tax court called a stipulation process. And in the tax court, discovery is not nearly the ruthless game that it is in other courts. And the parties are expected to stipulate to anything that they can reasonably agree to. So the more you can get your opponent to agree to stuff you say in your petition, the more likely it is that you will be able to get a set of stipulated facts that will allow you to not have to go to a trial. And we do everything we can to keep our clients out of a courtroom. That probably represents the place where they have the maximum disadvantage, is in a courtroom. They're usually there for the first time standing in a courtroom while everybody else in the room is being paid to be there from money that they take from guys like him.
Yeah.
They haven't got a chance. I feel bad for.
That sounds like summary judgment.
Yeah. Well, summary judgment's a process that we frequently see in tax court where they're trying to cut it short. But you're right. That's what it ends up being. It's just a very uneven David and Goliath battle if our client ends up in a courtroom.
Well, Chappie, is it possible we could take anybody's questions that they might have? Or
Sure.
Hey, good point. Yeah.
Let's do that for a little while. We got a few
Okay.
minutes.
Does anybody have any comments, questions, response? Speak up.
Yes, this is Joshua.
what is your website? Do you have a website?
We do. It's a substack. It's taxcourthelp.net.
I wasn't able to get on it.
Oh, you
Hey,
weren't?
wait a minute. Here. Tax court help
Try taxcourthelp.net.
.net.
well, were you looking for anything
heck.
specific while you're on the phone or on the line?
No, it was not.
Caller?
No, it was. No, it was not. Just want to investigate how I could use your services.
Okay.
I don't know why that's not resolving there. I will send you a link to it though, Yashua. If you want to contact me by text.
Sure.
Yeah.
Or email.
Sure. You can text me. No, not right now. Not at this moment, but I'll get you onto our website. And you can text me at 859-552-3000.
Okay, that's 859.
Can you put that in the chat?
Sure.
Yeah, put it in the chat. And be sure, folks, so I get my little cookies. I love chocolate chip cookies. Make sure that you tell them that Chris Chapman sent you, or Chappie.
Yes, and if anybody would like to talk to us, we're offering a free evaluation of your case. If you just send us a text with your name and the words tax help.
I have a question.
In fact, mention Chappie as well. That's a good idea. Sure. What's your question?
So in the case when you say sending the tax court a petition, the petition basically is the response to their notice of deficiency. Is that correct?
Generally,
Yeah.
you get to contest the notice of deficiency administratively.
Oh, okay. So okay.
But if that doesn't work out, then you're
Well, the notice of determination, or it could be a notice of determination from a collection due process hearing, or a notice of deficiency. Those are the most popular petitions.
The deficiency notice will come out of an audit. This is the examination process. You don't owe the money. The other type of case, the collections case, the tax has already been assessed and they're trying to collect it. And so it's a different species of action. It's really different.
Right. And then that would be, at that point, that would have to be done in the district court.
No. If you don't want to pay the tax and you want to contest it, you can contest it in the tax
Okay.
court.
In the district court, you have to do what's called pay first, litigate later.
Right.
In the tax court, you don't have to do that. You can just petition without paying anything.
Right. Okay. Yep. Great. Thank you.
And there is a question here. Where was that? Will this stop assessment? Not assessment. Will this stop garnishment? Yeah. Will this stop garnishment?
Well, what is this?
You go into tax court. If somebody wanted to go to tax court, they're beyond the notice and opportunity and all that, and their paycheck is getting garnished. Can that be stopped?
I don't know who asked that, but that is a very good question, because within the last year or so, we were speaking of the tax court's jurisdiction. Well, for years, since they passed the collection due process laws, they said our jurisdiction depends on a statutory notice of determination and a timely petition within 30 days. That's our jurisdiction. But in the Bechler case in the United States Supreme Court, they said that 30-day period is not jurisdictional. So that allows people like this gentleman here to perhaps go to the tax court late. You're beyond the 30 days, but the period is subject to what's called equitable tolling. So if we could come up with a good reason why you didn't petition within the 30 days, we could stop that collection action. And also, if you live in the Third Circuit, which is New Jersey, Delaware, and forget off the top of my head what else, but in that area, in the Mid-Atlantic, they have ruled that the 90-day notice of deficiency period is not jurisdictional. So if you miss that period, you can petition the tax court late and maybe get that assessment abated or collection action reversed. And also, one more thing, the tax court itself recently has ruled that when you request a CDP lien hearing after they file a notice of federal tax lien, that 30-day period is not jurisdictional. So you can file a late request to have a collection due process hearing, and the law is the same. The lien and levy laws read the same. They haven't had a levy case yet. But if you want to be the first one to get that favorable ruling that says, yep, you can stop a levy by filing a late request for a CDP hearing, then you can do that. So you have three avenues to reverse what you might have thought was, just a lost situation because you missed your deadlines.
Yeah, well, the guy that asked that question is also involved in a criminal case right now. So no, he wouldn't be able to do that while the criminal case goes on.
He was just asking the question.
No, I just saw who sent it and about the garnishment removal. He is now involved in a criminal case coming up next month next month. And
well, the thing is, Chappie, and maybe he could give us a call if he wants, but if this criminal case is accusing him, for example, of evasion of collection, if he's able to request a collection due process hearing now, then he hasn't evaded collection. We could probably do something for him.
Yeah.
In light of these recent rulings by the tax court, the Third Circuit, or not the Third Circuit in this case, but in the Supreme Court.
Well, he's working with two different people right now, going two different ways. So I don't know if a third way.
Put that out there.
Yeah, I know, and I appreciate that. It's just that people start, like drowning. They'll grab on to anything, and my main thing is I like to stay focused on something. I've been in that grab for anything, and it's not a good place to be.
Well, I think the basic point we want to make on those three court rulings is that if you thought that, however it happened, and I described various ways, the certified mail notice, blew off the door, you didn't get it. Well, now, unlike before, there are ways that you could reverse the whole collection process. But of course, we would need to know, the individual details of your case.
Right. Okay. So is there any other questions, comments?
Yes.
Raise your hand. Go ahead, Marla.
Joshua.
Oh, go ahead, Joshua.
Yes. My issues with the New York State Department of Taxation Finance, the acting commissioner and general counsel. Okay. Well, they decided I actually filed a civil action against them back in October of 2022. Unbeknownst to me at the time when I did that, the Amanda Hiller, who's currently the acting commissioner and general counsel, decided to retaliate against me, but I wasn't aware of that. It was regarding a 2004 income execution, they call it income execution without filing a warrant.
So that's a letter.
And so, and I was a victim of that for nearly 19 years. So when I filed my case, unbeknownst to me, it was actually on October the 5th, 2022, and it got served October the 16th, November the 16th of 2022. 9 days after that is when they did something very egregious. They terminated the old tax income execution warrant and replaced it with a new one for $133,000. And so, and it didn't actually, it was being executed when it was created, but it didn't go to paper yet. Around December the 6th is when that this document that they created was signed off by this other gentleman named Josh Russell. And I received this notice and demand.
This might sound like something that we should address personally, because this sounds very detailed, and New York State income tax collection can be very.
You got it.
We've got a case right now that we're dealing with those folks. So maybe, Chappie, we can, talk to this gentleman.
The offer of a free evaluation of your case still stands. We can do that for you, Ashra. But we really have to get into the weeds. Maybe your case can help us on the other case that we're currently working on, and vice versa. So,
long story short, just long story short, the case that my civil action was disposed of, and all the emotions behind it was rendered moot. However, before that happened, when I had filed my restraining order, it was granted, and then followed was a contempt, which was sitting before the judge, and I made the mistake of withdrawing, and I should not have. But I didn't know of these facts of what they were doing behind the scenes yet.
Right.
Right now, I filed a motion. It's called a 50-50 motion to vacate the judgment order based upon fraud, misrepresentation, fraud upon the court. I attached the evidence to the affidavit along with the motion and the memorandum of law. And so they got to the 25th. That's the submission date of this month. So that's where we are now.
What court is it in?
It's Supreme Court of the State of New York.
I see.
Right. Well, keep us, or as Lysander said, we can examine your case in detail or evaluate it if you'd like us to.
Sure. What I was planning on doing was PDFing the documents that I filed in court so I can make it easy accessible to you and
That'd be great.
Excellent.
That's how we roll. We like electronic documents.
Yep. Love documents.
We don't handle much paper.
Right.
We handle a lot of scanned documents.
Definitely.
Anybody else, Chappie?
Anything else?
Okay. Well, when I unmute myself, people can hear me a hell of a lot better. Okay. Is there any questions, comments?
I have one more question, if possible. This is Alexis.
Yeah, go ahead.
So I do some law classes once in a while for my local church, just to try and get people a little bit more law literate. And I'm going to do one on property and taxes this coming around. What is, people have been doing this for a long time, obviously, by the sounds of it. And I'm trying to assess a quote unquote proper recommendation. Is this something where, is it worth doing just to quote unquote save money? Or is this really just an act of kind of patriotic duty? And if you're just there to save money, don't do it.
If you're just there to save money, don't do it.
Okay. All right. Yeah.
Because what you will spend in time will far exceed what you save in money.
Yeah. Now, wait a minute. What's the nature of your question? Not to pay taxes is just to save money?
Well, people do these things for different reasons. And I mean, my personal experience is exactly what Lysander just said, that, and by the way, my tax liability has always been extremely small, but I just didn't feel right continuing to pay to abusive government.
No, yeah. When I talk to people, I ask them, how come you don't pay, you don't want to pay taxes? And if they say, it saves a lot of money, I just tell them pay the tax and don't have to look over your shoulder. I really ain't got time for you.
Yeah, so far I think I've paid. My pay has been $1 an hour.
This is not just a financial battle. I mean, this is an effort to expose some very serious wrongdoing. This is among the largest crimes our government
this is a spiritual battle.
Right, exactly. But they're committing so many crimes. I used to think this was the biggest. I'm not quite sure.
Right. Yeah,
If
yeah,
I like to
yeah.
interject,
Sure,
um,
please.
every year I do file an exempt W-4, even though I know that I'm legally not required to do so, but there's many levels or levels of this, as far as understanding, because I understand section 61A, 63A, section 83A, 3402N, 30, subtitle C, chapter 24, and what have you, and how they work together. And when I'm challenged on that, I just kind of like try to very simplify it, because if I'm not receiving any taxable income, which is clearly defined in the code, then I have no liability, no, to personal income tax. And so I pretty much explain that. I haven't had any issues from the federal government, at least not yet. I'm only having issues from the state. They think they are autonomous and separate from that. And yet they have governing statutes that holds them to that, to the standard, which is
Yes.
federal law.
Yes.
The
So,
Internal Revenue Code.
and
Yeah.
Most
Exactly.
states are like that. Yeah.
and so that's where the problem is with the state. The state don't want to adhere to their own statutes, much less the federal law.
Yeah. Our experience has been that state revenue collectors are much more high-handed than even the IRS.
Right.
Okay, well, it's past the top of the hour. I'm assuming that nobody else has any questions, comments, or statements. Going once, going twice. All right. Well, Lysander and Ed, I really appreciate you coming on the call. If you like, we can do it again and say within a month or two.
We can do that. Sure. That'd be
Yeah.
great. And
And
hey, I really appreciate your having us on and holding this forum. I appreciate the people who have showed up to listen to this. I understand that this is not light entertainment.
no,
So
it's
certainly appreciate you all being here.
I just wish that everybody, I mean, everybody knows. I think timing is always comes into play. And with the political screen right now going on in this country, everybody knows, whether they want to accept it or not, that this government is totally corrupt. And there's nothing good about the people in our
100%.
government. While our government is the perfect, um, I mean, it's next to perfection. It's just the people in government are not, and they completely went the opposite way. And the best way, in my mind, I'm sure there's other ways, but if we can prevent their tax people, if we can educate more than enough people to learn what we know, then we can start making an impact on the Federal Reserve System as well as the IRS and so forth. And so again, this is kind of like a plea. I got 3 or 4 home-based business that I'm involved in. Even one, teaming up with the that actor there, saving the children from getting um, um, kidnapped and everything. It's I got some great opportunities that are really inexpensive, but you can make money. Now, when I say make money, not to go buy fancy cars and big houses, but get prepared to what's coming. And I got several good resources that I'm going to be putting out some videos and emails about what's coming. And you're going to need storage food. You're going to need solar power, type equipment and everything else. Filtered water, storage food, even maybe a pup tent. But whatever it is, you got to get prepared. And if you never have to use it, great. Go play in the backyard with your grandkids and camping. but at least you have it, and you're going to need it. Always be prepared. I was a good Boy Scout, I know. So anyhow, I'd like to thank everybody for coming on the call. And nothing in this call is determined as legal advice. We're just here giving our opinions and what ifs and what we may or may not can do in the help that we offer. So God bless America. This call is now officially over. Good night,
Thanks for the
everybody.
time.
Thank you.
Thank you,
Bye.
Chappie. Good night.
Right, Chappie.
Amy.